Mr. Owens, you are muted, sir.
Attempts to try and coordinate and not gotten anywhere with that. I am not even sure what he is going to do.
Judge? Hang on, let Mr. J finish his point, sir.
Not sure if he's going to be testifying to battered...
Judge? Hello? Mr. Owens, we can hear you loud and clear, sir. Judge? Yes, sir, we can hear you. Judge? Mr. Owens, I can hear you. Judge? Sir, I can hear you loud and clear, sir. Judge Kleiner? Yes, sir, we can hear you. I can hear you. Judge Kleiner? Judge Kleiner? I can hear you. I can't hear you. I can't hear you. Judge Kleiner? I can hear you. I can hear you. Judge?
How are we doing, everybody? I thought we'd get together today. Let's talk about some of these motions that have occurred over the last couple of days, because I really have not done a true docket update. We'll talk a little bit about the outcome of this past court hearing and get ready for what's coming next week. So let's get to it. Okay, I'm going to start from the top and go down, and then we'll go from there. Okay, first up, notice of provision of state's amended witness list. Basically, the state has updated their list, and they've sent the updated version to the Owens team. At this point, we don't know if the Owens team is just him and Margaret with Henderson on the side, or if he truly has a co-counsel of Beck and Henderson. Notice of placement of a state witness on the state's Brady list. Joseph O'Neill of the Orange County Sheriff's Office. This is attached to one of the previous cases, I believe, because Joseph O'Neill, he wasn't in any of the death investigation police reports that we've just previously reviewed this past week. So he has to be connected to one of the other incidents where they called 911. Both these past two motions were filed by Cacciatore, not Prosecutor Jay. Then, of course, we have the notice for the hearing that's going to occur on Wednesday at 3 p.m. Eastern Standard Time. I wanted to know if this was going to be held in public. I did put a link up to watch this, to be live for this, but I read somewhere that they were talking about doing this in the judge's chambers. Well, first of all, the motion to suppress defendant's statements at Orange County Sheriff's Office, they're going to discuss that further. As we know from watching this past hearing, Judge Kranick has fussed at him again, stating, "You're not giving me a legal reason why this should not be in." I just don't. I think he's doing everything he can, throwing, like they say, noodles at the wall, trying to get them to stick, because nothing is going to keep this statement out, I don't think. But he's going to keep trying, and I guarantee you that on Wednesday's hearing, in addition to this, he's going to bring up those other two items that he was supposed to file an amended motion suppression on. And when I say the additional two things that I'm talking about are the body cam footage with the first officer on scene, the female officer, and then also the audio of her interview in the police car at her apartment complex the day that they all arrived on scene. So in addition to the interrogation of the police department, they also want those two items. He's basically said, you haven't filed these properly for me to consider suppressing those other two additional items. You've only filed something in regards to the statement at the police department. He had until midnight of last night to refile his motion. And as you can see, nothing was filed. So is he giving up on those two? I don't know. He may not have had time because he had to go do an interview with Court TV last night. Who would like to see that right now? Let's watch. And old Frank, too. Frank was there. Frank is eating it up. He said, you know what? I'm going to get paid on this case one way or another. His feed with the court TV people, that was bad too. So. We'll watch as much as we can stand. How about that?
And thank you so much for being here. Also with us, Sarah's former defense attorney, Frank Bankowitz. So I wanted to point out a couple of scenarios here and kind of get your take on it. And I'll begin with Sarah Boone talking about when she woke up. In one statement, Sarah woke up to her cell phone ringing multiple times around 1100 hours. This is in a police statement. She went downstairs, did not see George anywhere in the apartment. She then realizes that he was possibly still inside the suitcase. Sarah unzipped the suitcase and found George unresponsive and not breathing. However, on the body cam video, I want to play that so we can see if it's consistent with that version.
When did you do CPR?
This morning,
When I found it.
before you called.
Yes!
1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30ish. Whatever.
So James, is there a problem here in when she's getting up, or is this story consistent, at least this part, of when she gets up the following morning?
Thanks for having me, Vinny. I don't think she had a watch on every time they're asking her questions about the times, guessing, trying to give them an answer. So I don't think she should be looked down upon or considered that she's being evasive. I just think she didn't know the time frame.
Frank, from your perspective, is there a problem with her story, or is it something that is consistent enough for a jury to say, hey, every time she's telling the story, she's telling the same story about what happened that morning?
Well, I don't know that you can point to inconsistencies. I think it's, she's nervous, she's upset, she's basically kind of in a panic mode from what I see in the video and what I've seen in the past. And I don't know that you can point to those as being inconsistencies.
I want to show go to another issue here, which is the state of mind that night and what was happening.
Drunkenness, not drunkenness.
James, from the beginning of my coverage of the story, that's always been a big issue because you listen to the voice, it sounds like she's under the influence. Is this a problem? The fact that she seems to be denying that they were drinking, denying that she was drunk, or was she actually sober that night?
No, I think they were drinking, and I think that earlier in the day, she to the Publix, which is a short distance away from their apartment. And then later on the day, he went a second time to Publix and got another bottle. So both of those and found in the garbage can, and the receipts were found somewhere in the apartment. So
I love that he's addressing the whole Publix thing, because now, well, at least on our channel, now we're completely aware that there were 3 Publix receipts and that there were 2 visits to Publix that day. Oh, you know what? I need to say something. And before I forget, I know everybody has different grocery stores, right? In Florida, the big grocery store there, the nicest grocery store, well, I say one of the nicer grocery stores in Florida is the Publix. It's spelled Publix. They're usually a very nice, more newer grocery store. Has a big deli, big bakery, all that good stuff. So I wanted to put that in there too, because I didn't even think about the fact that you guys might not understand what Publix was, but it is just a grocery store. I do love the fact that he acknowledges that there were 2 visits that day to the Publix. That's the first time we've heard from their side that there were 2 visits, because remember when in Sarah's interrogation, she said that George was the one that went to Publix to get the wine. Don't y'all know George does everything wrong? And the other thing too is what I from what I understand, I have not seen it yet, but the first visit, which was earlier in the day when possibly they were not drunk, Both of them went to Publix. There's no telling with her, though, you guys. Time doesn't matter with her. She could have been drunk, like her neighbor said, at 9 a.m. So I could be completely wrong on that. But I just thought it was more likely that she was not inebriated at that point in time when they took the first visit to Publix. And if so, then why the heck didn't she remember she went? Because she told the police in the interrogation that she did not go. She did not go.
So they were the only in the apartment that night, so they both consumed so they did drink quite a bit.
Frank Bankowitz, let me ask you about that issue of the drinking. Is that a huge problem for Sarah Boone that they were drinking, or how does this play in front of a jury, and what does it mean?
Well, I would agree with Mr. Owens. They were drinking a lot. They consumed 2 full bottles of wine. They finished one and went out and bought a second and finished it. Whether in her mind at that point in time she can establish whether she was drunk or not, I think that's going to be a question for the jury. And they're going to have to look at all these tapes and look at the actual facts as to what she did, where she had gone, and the fact that she, quote, fell asleep, to me is consistent with being passed out. But that's to me. Fortunately, I don't have to deal with that. Mr. Owens does.
Mr. Owens, number 9, will be representing Sarah Boone at the trial.
I think Bankowitz is still a little sore about being called a buffoon.
This is a big one now. I think this is probably the biggest one if there is an inconsistency. From the beginning, it seems that Sarah was talking about playing a game of hide and seek, that George willingly got into the suitcase. Sarah zipped the suitcase up, and they were both laughing as she zipped him into the suitcase. But now I want to play the last time, James, you were in court talking about what Sarah's defense is going to be in this case.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
All right. So I love that they picked the one little piece, one little clip there. They're like, damn, we got to find a clip that makes him look pretty good. I guess we'll go with this piece. Now, and I know they were going for the shocker, the whole shocking thing about, they're going with the self-defense. For me, when this came out in court, I was like, this wasn't a shock to me. I don't know why everybody was like, they're really going with it. We were talking about it a week before all this happened. We were diving into the whole battered spouse thing. So I just think it's funny.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay. They want. Sarah said that.
Okay, James, let me ask you, if they're laughing, if she says they're laughing when she zipped him in, how does that equal self-defense? Is that inconsistent?
Thank you, Benny.
Well, like I said in court, the video is only 2 minutes long that Sarah recorded of George in the suitcase. So no one but Sarah knows what happened prior to recorded, and no one but Sarah knows what happened, turned off the video.
So is he admitting to the fact that his client lied to the police?
So for to testify to and explain what happened.
domestic violence in this relationship? And if so, how serious?
Absolutely. There's a long history of domestic violence, and I'm sure all of that's going to come out or has already come out with regard to the battered spouse defense. That's one of the principal elements is to establish a history of abuse. And there was a long history of abuse in this case, history of hospitalizations, history of broken bones, history of arrests. It's a classic situation of battered spouse syndrome.
I love how he pumps it up. A history of hospital visits. We haven't seen the medical yet because all that's HIPAA, but I'm sure we'll see it soon. The only incident I know where they went to the hospital was when George and his brother got into a fight, and he was sent to the hospital because his brother tore him up. And as far as Sarah goes, there was some talk of him doing something to her leg, but I haven't read anything in any of the reports regarding that. So for me right now, it's only hearsay until it comes out in court, because I have not seen it brought up.
James Owens, this history that we are uncovering here, is the jury going to see and hear about this history?
Yes. The filed a notice of intent to rely on, and in the notice and in the amended notice, we alleged that there were prior incidences of abuse, and Dr. Julie Harper to testify on that issue. So yes, there is corroboration in terms of a prior history of George and emotionally and sexually abusing Sarah Boone.
Spit it out, James. But you know what, Vinny? Don't feel bad that he's not really giving you any information. He's pretty much just repeating to you what he said to the judge. I think he's on a loop. He's on a loop of remembering what he needs to say right now. It's so ridiculous. You guys, it's so ridiculous. Now they're talking about his history of arrest or what have you. I want to say one thing here. If you guys watch this all the way through, he was arrested 4 times. That there might have been 5, but there was 4 times that we could tell. I have a video on my channel where we went through the arrest of Jorge Torrez Jr. And it needs to be made known that up until he was involved with Sarah Boone, there were no arrests on his record for any type of abuse or battery towards anyone. The only thing on his police record was like something having to do with a traffic violation way back when. I do believe that the prosecution seems to be on their game. I certainly hope that they will make note of this. It's got to be made. They've got to come back with that. I mean, if I can figure it out, they can, right? He was not this raging guy that was beating people up all the time. You want to say that he was abusive towards her? Fine. But I won't settle on the fact that she wasn't abusive to him. And I have always believed that she was the aggressor in the situation, not him. And so let's move on. Let's go back over here to the docket. Okay. So then we have the court's minutes from the 27th, where they basically have said that the defense, and this is very, very important, the defense must file motion to suppress by the end of today, 11:59 p.m., because, he had to question the judge on whether or not he meant the end of the day or the end of the business day. The court will then rule on the defense motion as it relates to hair and makeup in chambers. Okay. I love that he put it in chambers because he realizes how freaking ridiculous this is. And you guys, my favorite statement from Prosecutor Jay, in addition to all the other good things that he was throwing out, clapping back at Owens yesterday in the hearing, was that he said, she will be the first ever in history to have hair and makeup done in this courthouse. I love that. So anyway, as you can see right now, there's nothing on the docket. Now, did he file it? in time. Maybe it hasn't uploaded. Maybe he sent it in time. Maybe it won't pop up until Monday. But as of right now, we are still waiting. Okay, so then the state is to depose Dr. Brennan in person no later than October the 3rd. The reason that they're putting this down was because there was a bunch of back and forth in this last hearing that was absolutely ridiculous. Get him on the phone. You know, working with James Owens is like trying to pull teeth, because you try to get some information. The judge is leaning towards him going, okay, I understand what you're saying. I hear what you want. Explain to me in legal format why I should give it to you. And James Owens is like back on his little loop-de-loop of things that he says. And it's the same thing. Dr. Julie Harper, battered spouse syndrome. We're going to bring in Dr. Brannon. He never comes back with anything solid. All right, then we go over here to the motion to strike, defendant's motion to suppress statements at the Orange County Sheriff's Office, and motion to strike, defendant's motion to suppress statements at the Orange County Sheriff's Office. We read some of this yesterday in the hearing. I want to read it again because everything was so chaotic during that hearing that I couldn't absorb it. So I want to read through it again, and I want to give you guys my take on this, and we'll go from there. And this is coming from the state. The defendant's motion is legally insufficient. The defendant recited allegations of facts, but not why any particular fact or facts is an issue. The reasons for suppression, as required by Florida Rule of Criminal Procedure 3.190, is a boilerplate assertion that it violated the United States Constitution and the Florida Constitution. This is no different than stating a search was performed illegally and improperly and unlawfully. So they reference State versus Christmas here. Motion to suppress that cited 11 authoritative cases was legally sufficient. The defendant has not cited even a single case that authorizes the court to grant her the relief she is requesting. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. State versus Butterfield. And then he says the court should strike the motion as legally insufficient. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion, State versus Christmas. In paragraphs 5 and 6 of her motion, she alleges that she was detained for 14 hours, and during this time, she provided a statement to law enforcement. And again, we've questioned this whole time period of 14 hours. That means they would not have left the crime scene. Well, if they got there at 1 p.m., so they're saying they were on scene till 4 a.m. At any point in time here, this is what I think is, could it have taken them that long to process? Possibly. But at some point, they would have turned to her and said, "Bam, you can't stay here tonight. You got somewhere else to stay. Go and do your thing." She wasn't being held. She wasn't being detained at that point. So during this time, she provided a statement to law enforcement. She does not challenge the admissibility of this statement. Chavez versus State, where they mentioned 54 hours of detention does not make a statement involuntary. So it doesn't matter how long she felt that she was detained. Paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked for the defendant to turn over her phone and that she provided the means to unlock it to law enforcement. Bell versus State is informative on this issue. If it is the defendant's position that this somehow rendered her statement the following day involuntary. Bell makes it clear that the police, having seized evidence from a suspect and the suspect knowing they have seized the evidence from her, only goes towards the analysis as whether a future interrogation is custodial, not whether a future statement is involuntary. And again, we've got her waiver for the phone in writing. Because Miranda warnings were provided at the beginning of the interview the following day, this is not a relevant factor for the court to consider. Now, in Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below. So paragraphs 9 and 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning her for an interview Remember how he said they coaxed her in there, Judge. They made her feel like she was coming in there to get something else. She did not know what was going to occur. So what? Who cares? Many times people that are being arrested have no freaking clue what happens next. Pursuant to bail, this goes to one of the Ramirez factors in deciding whether Miranda warnings were required, not whether a statement is involuntary. This is different from the deception that would lead to an involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Johnson versus State, 268. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. And then they reference Weich, I think that's Weich versus State. This includes misrepresenting a co-defendant's statement, false suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against a suspect, informing a suspect that law enforcement was investigating a missing person rather than a homicide, writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representations of physical evidence that did not exist. Luring the defendant to the sheriff's office under the guise of returning her phone to her, if that is in fact what happened, does not make the statement involuntary. It only goes towards whether Miranda should have been read as it was. It's funny that he says that, if that is what happened, because as we know, that's Sarah saying that's what happened. And I think I've mentioned this prior. It may not have been all that. It may have been a simple phone call that they made and said, do you mind coming down here? It'll be interesting to see what they say she said, because we know she keeps getting caught in all these lies. And I do believe it's going to pile up, and the jury's going to eventually, over just a few days, they'll start to see, damn, she lied to everybody. Just one witness, two witness, three witness, four witness. They're all going to start coming in, and the jury will see the lies. They have to. God, please let them see them. Paragraphs 12 and 13 also only go towards the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued after Miranda was read to the defendant. Nor is there any coercion. Although the defendant has not specifically made that claim or cited authority, Martin versus State, 107, allegations that law enforcement, number one, threatened the suspect with the death penalty, and two, deluded the suspect as to what he could expect for himself or from a jury if he confessed. Three, deceived the suspect as to the amount of time he had to cooperate with law enforcement. Four, promised their favorable testimony and use of their influence during his trial if he cooperated. 5, promised to arrange a visit for him with his girlfriend if he cooperated. And 6, exploited his religious beliefs by relying on a version of the Christian burial interrogation technique. So he goes back to say all those did not render the statement involuntary, though it presented the very outer limit as to what tactics law enforcement may employ when performing a custodial interrogation. Although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law, again, on the subject, the state infers that she believes this is an issue due to what she has underlined in paragraph 15 of her motion. There are several cases addressing the issue of minimizing the importance of Miranda warnings. Ross versus State, Thomas versus State, Rios versus State, Wright versus State, I think it's Chafin versus State. Saying this is something that I have to do is not minimizing according to Wright versus State, which is analogs to Detective Copsell saying, so I'm going to read you your rights again because we have to talk about that. We just have to do it. They were read in a normal cadence like in Chafin. There was no delay in reading them. The defendant is not a juvenile, and there was no claim that she is or below average intelligence. Well, I mean, that's your opinion. She has been read her Miranda warnings just the day before and acknowledged this. It is the defendant who says, it is normal protocol. Because, he threw that out there. He was like, Judge, they're telling her it's protocol. It's not protocol. It's not protocol, Judge. These statements by law enforcement did not render her waiver of her Miranda rights involuntarily or her statement involuntary under a totality of circumstances analysis. In the balance of paragraph 15 of her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Koffelotz. Paragraphs 17 through 21 outline what she believes the sheriff's office Miranda card says and how it differs from what she was told by Detective Koffelotz. Interestingly, the defendant's belief that creates some sort of legal impediment to the admissibility of her 2-hour statement that day is not backed up by a single citation to any legal authority within or without the state of Florida's court system. Instead, she makes a boilerplate assertion in paragraph 22 that her statement was involuntary and her waiver of her Miranda rights was involuntary. Fortunately for the state, there is case law on this issue. There is no specific way that Miranda warnings must be given, and with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. Ooh, I love it. You go, Prosecutor Jay. Then he references more case law there. While the 4 required warnings have become embedded in police practice, the specific words used vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. Morris versus State. There is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. The crucial test for determining whether police gave a proper warning is this: whether the words in the context used, considering the age of the person being questioned, background and intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. I think there's kids out there that could state the Miranda. You know? Anybody that watches these shows, TV shows, knows it. Detective Koffelotz specifically instructed the defendant on each of her 4 Miranda rights. Number 1, right to remain silent. Number 2, that anything said can be used against her. 3, she had a right to an attorney before and during questioning. And in my opinion, that's the biggest one. 4, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if he understood these rights, and the defendant said she did. State versus Owens, indirectly on point. There, the defendant was read 4 Miranda rights, asked if he understood them, and asked if anyone had threatened him and promised him anything. There is no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which were described as exemplary. The Miranda decision never contemplated that waiver of counsel could be accomplished only by the use of few words. I'm willing to answer your questions without the service of a lawyer. There is no magic in these words. Any clear and an unambiguous conduct by a person who has been advised of his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. State versus Craig. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny it on its merits. And I love how he's like, okay, well, Judge, if you're going to go forward with this, I mean, even though it is legally insufficient, I mean, let's talk about the merit part. If the court believes there was a Miranda violation, the defendant's statement are still available for use during cross-examination. Under bail, only if the court finds the statements to be involuntary will the statement be prohibited from using them in cross-examination. Then he gives his certificate of service because, you know, that's what they do. They do a certificate of service there at the prosecution's office, like everybody else. William Robert J., Assistant State Attorney. Doot, doot. You go, Prosecutor J. All right, let's see. We got this motion. And this is the motion for hair and makeup. I mean, this, you'd think we were on a Hollywood set. Jesus, my kneeses. Good gracious alive. Comes now the defendant. Defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. Without restraints for trial. Okay, you know, here's the thing. this would be an argument for her not to be wearing restraints at trial. If you really think about it, let's take away all the hair and makeup. Let's take away all the Hollywood drama that James Owens likes to tack upon everything he speaks upon. And let's just think about this simply. At the end of the day, I believe what the court is going to rule on is whether or not she has to wear restraints while she's in the courtroom. And most of us know, like, these prisoners are brought in, they have handcuffs on. Once they sit down in their seat, the handcuffs come off, but the cuffs around their legs get cuffed to the little thing underneath the table that nobody can see so that they can't run or do anything. There's a tablecloth covering all of that. And then they bring the jury in. So the jury truly never sees that. So it's really a moot point. Sarah's not defending herself anymore. Sarah's not going to be standing up, moving around with a portable microphone like Mr. James Owens wants. So I don't understand why this is such a big freaking deal. I just don't understand. Now, what's different than her than maybe some other trial that we previously watched? Well, she's going to get up and testify. If they're going to claim battered spouse syndrome, she's going to get up and testify. So what's she going to be looking like when she gets up to walk to the stand to be sworn in? Is she going to have chocolates on her ankles? Is she going to have bracelets, little metal bracelets? We think what she's going to have is probably just handcuffs. She'll be put on the stand with the guard. She'll be put on the stand, and then they bring the jury in. The jury doesn't see any of it. It's not just to protect her rights, because God forbid, we know she's gotten all the rights she's deserved at this point, and then some. It's to make sure that this trial can't be put on appeal for her being mistreated or made to look bad. Let's face it, this woman makes herself look bad. She don't need anybody else's help. So it comes before the judge, defendant to appear in all court proceedings pertaining to trial in civilian clothes without restraints instead of jail uniform. In addition, the defendant requests that she be permitted the right to have her hair styled and access to makeup. In support thereof, defendant states the following. All right, first of all, you guys, we laugh about this motion and all that, and we make fun of this stuff because Sarah Boone is so ridiculous. And now she has a ridiculous attorney. But the beauty in all of this is that you can hide this, you can hide that. As of this weekend right now, we believe that Judge Cranick is watching those interrogations. I think he's watching the 2-hour interrogation at the sheriff's office. Now, he's been around Sarah since he came on board. I'll have to go back and look at the date that he came on board, that he became the judge in the case. But he's been around long enough to realize how she is. He's done very well with his patience with her. But the beautiful part of all this, guys, is that this is the man who's seen all this and is reading all these ridiculous statements. This man right here, this is the man that's going to sentence her. And, oh, we cannot wait. The defendant is presently incarcerated and is scheduled for trial on October the 7th of 2024. Defendant has been incarcerated for over 4 years, and defense would like access to professional hair styling, cosmetics, and civilian clothing without restraints throughout defendant's trial appearance in respect for the court and prospective jurors. So I guess they're going to contact Fantastic Sam's and have them come over every morning to style that little thing that sits on Sarah's head. Do they want to go with an 80s do? That's probably all you can do with that thing is go up. You really can't go down. You can't go out. There's not a whole lot you can do with that style. It's pretty fucked from the beginning. Excuse my language. I'm excited about this, but let's hope that the stylist says, you know what? This is the stylist walking in, y'all. The stylist walks in and she says, "Oh, hey, how are you? Listen, I've seen you on TV. What I'd like to suggest is, before we get started here today, styling your hair, I came a little bit early because what I'd like to do is let's why don't we try to give you a couple let's try to go with some layers or something. Let's give this bold Hamlet looking thing, cousin it wannabe thing that's sitting on your head, and let's do something with it with a little bit. We'll trim it around. We'll give it a little bit of body on the edges. I mean, because technically they probably could do something that was in style not too long ago. It could still be in style is where you do one side a little bit shorter than the other and then that style is kind of lifted. You know, I'm not saying they're going to give her a perm or anything, but I was looking through the hairstyle books the other day thinking, what on earth could you possibly get away with that hair? And, you know, I might just do that. We might just spend some time one night flipping through the hairstyle magazines and put up some photos of what could possibly be done. Without the court entering an order permitting her access to such, the right to receive a fair trial will be impermissibly infringed upon. Okay. That's crap. Let me tell you why it's crap. It's crap because you're absolutely incorrect. And once again, oh, he does say, okay, he's putting some legal argument down here, so we'll give him that much. Well, let me get to that part. They have to allow her to not look a mess. They can't bring her in there with dirty clothes, smelling funky, and her hair not brushed. They do not have to give her hairstyles. They do not have to give her makeup, or they do not have to allow her time to have makeup put on and a professional hairstylist. Is James Owens paying for this fantastic Sam's lady to come over and do all this? I wonder. See, I know y'all were getting all excited thinking it was a little bit higher level. You know, like maybe they were going to pull somebody from a nicer salon like Beat or something. Yeah, no, it's going to be a fantastic Sam's. We're talking about James Owens. This is the man that builds something up to where it's something, we're going to go get the most expensive hairdresser in Orlando, Florida, and we're going to bring him in, Judge. No, he's going to go down to the closest corner barber. Hell, he might even get a barber, not a real hairstylist, and bring him in. Seriously. Whew. Are we going to give her a little color too? Thinking about that. And I can just hear them bringing the Captain Giovanni back into this. Was it Giovanni? Isn't that how you said her name? Giovanni? At the jail, and them trying to talk to her about how this is going to happen with the hair and makeup. And she's shaking her head going, yeah, first of all, when we transport inmate, we have to get them up and going really, really early. It takes a long time, a lot of effort, and we have to worry also about the concern of the safety of our officers. I mean, let's just think about it from that aspect of the jail. They don't have time for this bull. All right, so let's listen to what his legal argument is. I think he did cite a few cases here. Oh, he did cite a few cases. Bless his heart. Okay. The presumption of innocence is a basic component of the fundamental right to a fair trial. Since the defendant, pending and during his trial, is still presumed innocent, he is entitled to be brought before the court with the appearance, dignity, and self-respect of a free, innocent man. Okay. Doesn't say anything about a professional hairdresser, though. He is therefore entitled to wear civilian clothes rather than prison clothing at his trial. Not a problem. Judge has already said you can do that. Why are you making such a big freaking deal out of it? Do you want us to bring a stylist in? Maybe we could fly somebody in from the New York fashion show to help you out. Here, defendant is scheduled for trial on October the 7th of 2024. The defendant will be transported from the Orange County Jail daily for her trial proceedings. Defense counsel will be providing the defendant with professional attire for the court appearance. Well, good for you. I love how he said, Judge, we got to get her measurements and everything. Just tell us you're going to go buy her a dang suit. I don't care. You know, it's just so stupid. In addition, the defense will need to obtain the defendant's measurements. He's going to go down to Dillard's and he's going to pick up an outfit. He's going to ask her to put it on. She's going to put it on and she's going to say, I don't like this. He's going to spin his wheels to send Margaret shopping at Dillard's. And if he's smart and he's figured out that she's going to be a pain in the ass, he needs to make sure he gets about 5 different choices of what Margaret's going to bring to her. Because she's going to have to wear something different every day or every other day at least, right? And it's a 3-week trial. So if he's going to incur the cost of purchasing her some clothes, he's going to send her down to Belk's. No, I take it back. I don't think he's going to send her to Dillard's. He's going to send Margaret down to Belk's, Cordova Mall in Pensacola on 9th Avenue. That's where he's going to send Margaret. Okay. There is a Dillard's in there, though. Wait. And, you know, they've got a shoe department, everything. So there you go. He's like, Margaret, just go get her a pair of black basic flats. Margaret's going to be like, Judge, I know just what to get her. I'm going to get her some black ballet flats. Perfect. Take my credit card and go down there. Now, you're going to have to get about 5 outfits, Margaret, okay? Now, listen. She's a pain in the ass, as you know. Get something that's got a jacket with it at first. Get something that she can wear one day with a jacket, and then she can wear it another day and she not wear the jacket and it look like a different outfit. And Margaret's going to say, well, and she might need a sweater. So let's get her a sweater we could throw on top of another outfit to make it look different. Perfect, Margaret. You're brilliant. I love you, Margaret. What else are we going to wear? Don't buy anything too frilly. Don't buy any jewelry. And I'm going to look at my credit card statement online after you get back to make sure that you didn't buy anything for yourself, Margaret. You got me? He's probably such a tight ass. He probably would do that. Oh, and Margaret, while you're there, listen, why don't you go ahead and swing by that perfume department, pick yourself something up there, okay? Maybe you would do that. I don't know. He's such a giving man. I mean, he did take on this case pro bono. Such a giving individual. Oh, Margaret. Girl. I'm going to Uber you a pizza. All right, let's see. I lost track of where I was. Allowing a defendant to appear before the jury in restraints. She's not going to appear before the jury in restraints. This is just... In restraint devices is an inherently prejudiced practice that undermines the presumption of innocence and the right to a fair trial. Generally, a defendant in a criminal trial has the right to appear before the jury free from physical restraints such as shackles or handcuffs. See Miller versus State. Fine. The judge has already said that that's not going to be a problem. He's already said that anything she's going to be detained with will not be shown to the jury. We've already gone over this. I will say this. You know, I guess Cranick has to give this guy the time for this. I just don't understand how they're still on this topic at this point kicking the can down the road, as ASAJ would say. All right. On September the 19th of 2024, the defendant appeared in court bearing handcuffs and shackles. Defendant's hand restraints made it difficult for her to communicate with counsel in written note-taking form. In addition, it is reasonable to assume that the next court hearings will be covered by local and national media. And if defendant is put on display to prospective jurors in jail garb, they will naturally be led to doubt in her presumption of innocence. You're right. That's what's going to make us think she looks guilty. What was I thinking? Oh, okay. I'm sorry. Where was I? Where have I been? Wait, no. Where have you been, Jamie? Therefore, defendant is requesting that the hand restraints be removed at court proceedings from here on out and that both shackles and handcuffs be removed during trial proceedings. We've got less than a week before trial. She's been doing this back and forth with the court for 4.5 years. Who freaking cares if she has to do it for a couple of more freaking days? This is a waste of time, and I totally understand why the ASAs are getting so frustrated with this crap that he's throwing on the... Is he throwing this crap on the docket because he's trying to make himself look like he's given a defense, and he's making... Like, maybe he knows he can't... Maybe he realizes... He can't fool those in the public. He can't fool everybody in the public with this. Maybe he realizes he can't fool the ASA with this. But does he think he can fool Sarah with thinking that all this is giving Sarah a fair shot at an innocent verdict? Right to control appearance in the courtroom and before the jury. The courts have recognized that a defendant's appearance can significantly impact the jury's perception and consequently the fairness of the trial. Estelle versus Williams. In Estelle versus Williams, the U.S. Supreme Court noted that compelling a defendant to stand trial in prison or jail clothing could impair the presumption of innocence, which is fundamental to the adversary system. Why are you writing this in? Why? Because the judge has already told you. Fine, bring in some clothes. Here. He gave Owens the name of the person that he could go talk to get some clothes if he didn't want to go buy any clothes. I mean, this is... Why are we talking about this right now? Allowing the defendant to present herself in a manner that does not unduly prejudice the jury is essential to ensuring her right to a fair trial and upholding the presumption of innocence. And while the court in Estelle specifically addressed prison attire, the underlying principle applies broadly to any aspect of a defendant's appearance that could influence the jury's perception. Defendant has a right to appear before this court and prospective jurors in the same manner as she would outside of confinement. Cosmetics and hairstyling is a standard practice in presenting a professional appearance if the individual so chooses. By extension, incarcerated males are permitted a fresh shaven haircut. Accordingly, the defendant's request that she be permitted access to cosmetics and hairstyling throughout her trial proceedings include voir dire. Is that how they say it? Voir dire? We don't care, James. We don't really freaking care. I wish the judge would say that. Like, don't you just wish he would just look at him and shake his head and go, we don't care. Whatever. Go talk to the bailiffs. Ask him if you can have an extra 15 minutes to fix the mop and put something on that crater face. Go ask for the time. See if they give it to you. It's not me that makes that decision. I do want to state one thing. Sam had made, Sam's been visited this jail, this Orange County jail that she's in before. And she said that their system is very strict. It's hard to get in there and see her. In fact, right now they're doing the digital call. Like, they have to come to, if somebody comes in to visit her, they would have to sit at this phone system or whatever, and they could do like a FaceTime, and she'd be on like another wall or something in the prison. So they can't even have in-person visits except for her defense team, right? They're probably glad that they're putting these motions in, to be honest with you. They're like, that's fine. We're putting it all on the record. It's all going on the record. But the judge would probably say after all that, talk to the bailiffs, see if they'll give you some extra time with your client before she has to come into the courtroom every morning. But again, it's on the record now. It would have been on the record, though, if they'd said that. The way he makes it sound as if he doesn't have access to Sarah, he can't do what he needs to do. It all kind of piles up into this whole big, multiple things that, again, go towards him saying, I'm doing the best I can, Judge, and not being able to get things done and not having enough time. We only got 9 days of trial, Judge. I'm doing the best I can. All right, now let's look at the next motion, which would be, I'm trying to think of where on the docket I stopped for you guys when we were leading up to this hearing. The state's response to the defendant's objections to the plaintiff's exhibit list. And you remember this objection that was supposed to be put in on the 17th, but weren't. All right, it says that on April the 3rd of 2020, the court entered a uniform order setting pretrial conference and trial. Part 1(4)(b) requires the parties to file all pretrial motions 10 days prior to pretrial conference, and cautions that late filings of motions to suppress may result in denial without hearing, per State versus Powell. The defendant has had copies of the statements she made to law enforcement for over 4 years. This is what he basically argued in court the other day. Now, at 11:43 p.m. on September the 26th of 2024, the evening after which her pretrial conference was scheduled, if the hurricane hadn't happened, they would have gotten this after, the evening after her pretrial conference was scheduled, files a legally insufficient motion to suppress her statements made to Deputy Caleb Rodriguez and the first of 2 statements made to Detectives Koffsalot and Lowen. This comes on the heels of another delinquent and legally insufficient motion to suppress statements filed on September the 24th of 2026, 2 days prior to the pretrial conference. It is unclear why these statements were not made a part of the motion to suppress filed on September the 24th of 2024. The court should require the defendant to file a proper motion to suppress so the state can enjoy a pretrial ruling on the motion and the jury does not have its time needlessly wasted. Judge Cranick basically said, yeah, I agree. We're not going to keep going doing this. We're going to get this done prior to the jury being sworn in. So that's part of what they're going to discuss, I believe, on Tuesday. The judge wanted to address it, I think, yesterday, but the motions were insufficient. I guess he has to give him does he have to give him a second chance to file another motion, amended motion? Because couldn't the judge just say, you know what, you're too late. It's late. We've given you an extra time, and this is what you come back with. No, denied. The state's objection to defendant's second amended reciprocal discovery exhibit list comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. The state received the second amended exhibit list at 10:44 p.m. on September the 26th of 2024. So on Wednesday, they shut down pretty much all of Florida, so they had to extend it to the following day. In that time period, utilizing that storm delay, he submits this information. The only apparent change was added in item number 13, which was jail phone calls involving the defendant and third parties when received. While the state may introduce statements of the defendant as a party opponent, the state is struggling to see any hearsay exceptions which would allow the defendant to introduce any jail phone calls. We saw it in the Jennifer Crumbly trial. No, not Jennifer Crumbly, the husband, James Crumbly. If you guys don't remember that, that's the kid that attacked the Oxford High School in Michigan. And remember, his parents went on the run. And so they brought him into court, and they were like the first parents that were ever convicted or even charged with actions associated with what their son had done. And so in James's trial, it was like the most dramatic time of the trial, I think. One of the prosecutors comes up and announces at the last minute, I think it was like at the end of the day or something, that he has phone conversations from James Crumbly, prior phone conversations recorded from the jail with someone else, an outside party. And that they say that they're going to bring him in the following day. Well, they were able to bring them in the following day because his phone calls literally were making threats towards the district attorney. But again, even if the jury doesn't see something like that, the judge will. But the judge is not, they're supposed to stay impartial and not include all that stuff. My opinion is that, oh, I'm sorry, I was sharing it. My opinion is that I don't see how you can unsee some of these things. I just don't. Now, here's where they did the filing for the discovery. Well, notice of provision of discovery. I'm pretty sure I've already looked at this, but this is the one where they're just stating that Detective Coughalot, there was a Brady violation, or there was claim of a Brady violation on her previously. They're putting the defense on notice of that. This doesn't have anything to do with her testimony. All this is they're saying she did have a Brady violation charged against her at one point, but it was thrown out. Nothing came of it. And from what I understand, this happens all the time where there's a case where somebody's being charged with something, and one of the first things the defense does is go and, especially when you got somebody that's clearly guilty, but their defense, will throw out Hail Marys just trying to get them things thrown out. And one of the things they'll say is that the detective did this or that wrong. Did we look into this? I'm trying to remember. I know I looked into her alleged Brady violation. I looked into it. Again, nothing came of it. I don't think I read it here on my channel. I just remember it stating something about, it was a case where they were saying, my memory on it's not great. I want to say that they said that she misrepresented the facts in the case towards, in regards to the search warrants and stuff like that to the judge. And her report was incorrect. It was something like that. But two, I want to take this moment to address the fact that we have not seen Kevin Beck. We've seen some filings from Kevin Beck. As you see right here, he's in New Mexico. So probably what's going on is he's going through and helping Owens with some of this law research, case research. I have a feeling, just because of the way everything's gone with this little circus, that three-man circus, three-man circus, three-man clown car, whatever you want to call it, the Three Stooges. I feel like they're all going to, when they come into court, it's going to be another one where they're not very organized in all of it. I just have that feeling. I guess we'll see. We'll see very soon. I can't wait for trial to start at this point. I really cannot. Notice a provision of defendant's amended exhibit list. a list of exhibits known to the defendant that may be relevant to any offense, charge, or any defense thereto, or to any similar fact, evidence to be presented at trial under Section 90.404. The one thing, and I know I've talked about this, I just want to bring this up really quick, though, is the order, because I think this is a big deal. Order on state's motion for court-appointed experts to produce reports, and they denied. The judge denied it, which I thought stunk. But they're going to depose her. They're going to depose Harper. They're going to depose Brannon. And I'm really unsure how Brannon and Harper are going to mesh together to make this work. It's like they're saying it's battered spouse, and we're going to have Dr. Harper come up on the stand and say that she's met with Sarah, she's done all her, and then you're going to have Dr. Brandon come up on stand, who supposedly, who nobody set a time or date with, who nobody's truly heard yet. So we really don't even know for a fact. We know he exists. He's been on court TV. I'm just kidding, you guys. No, he's very highly sought after. But he's done a lot of media. I almost feel like this is, what did they call that? A red herring? That what's his name's throwing it out there. This guy's going to come up and testify, and the last minute we're going to find out that he's not. But supposedly yesterday's arguments were about them trying to schedule the meeting with him. So we'll see. I don't know. I just don't understand why you need him, why you feel you need him. Is it like it's like, okay, if plan A falls through with Harper, something happens while she's up there giving her testimony, and her cross-examination kills her testimony or something, and it doesn't sound as impactful as we need it to sound with her, then we're going to throw Dr. Brandon up there on the stand and have a second person's opinion. Is that what it is? Is that what we're talking about here? Because it's just, I'm confused by that altogether. Good gracious. So that's where we are, everyone, until today. I'm trying to think of what else I wanted to show y'all. I've got some documents here. Let's see. I did make some more notes. I was looking back on my notes for Padilla, and I know we had talked about who Padilla had hired as an expert witness in regards to her psychology. And Dr. Edward Wiley was one. And then also at some point, there was a domestic violence psychologist under the name of Dr. Heller with an H. But of course, that was Padilla. That was the very first attorney on the case, and nothing else ever came of that. So, and in my notes, there's no mention of Harper, but we know Harper was involved back when Padilla was first on the case. So I don't know. I've already looked her up. We've looked up her photo before. Do you want me to pull her up on LinkedIn? Let me see if I can pull her up on LinkedIn. She had testified in something. Oh, I made a note. What was it that she just recently testified in? Oh, that's right. She's supposed to be testifying in this case that we've got here. Wrong. You guys? This is weird. Because this picture right here, I guess that's her. She looks really different, though, than this picture than the one that we saw of her in her other thing. But this is her. This is all the stuff that we read about. All this is the same. She's endorsed by 6 colleagues at Bridgewater Center. That's what I'm going to do, though. I'm going to try to find the cases that she testified on. I think that's the... Oh, sorry. Did I not show that? Doesn't she look different than that in this picture than the other one we showed the last time? I guess it's because her hair is darker and she's wearing glasses, but it's the same woman. So what I would like to do is go through and find some prior cases that she was on. See if I can't, since it is Florida, I'm sure that I can find some times when she testified, and I want to hear what she's going to say. And maybe, just maybe, a good idea would be for us to listen to the many different times that she's testified, just bits and pieces of that. Not the whole thing, trust me. Not the whole thing, but bits and pieces. And maybe I can analyze this down and do a couple of sections and show you guys where she repeats herself over and over again, which I know it's some of it, you know, it's science, whatever. But I just wanted to say I really appreciate you guys so much, and I appreciate how kind you've been over the last few days, and how just how sweet you guys are to me, and how much trust and faith you have in what I'm putting out there for you guys. So I hope you will continue to come back, and I'll have more for you a little bit later on. Stay tuned. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.